Good morning, everybody. Thank you for coming today to our 2025 Fair Housing Symposium, hosted by the Santa Monica City Attorney's Office. And we have a number of very special guests with us today from outside of our office. We're happy to be giving an opportunity to speak with you all today. My name's Romy Gansha. I'm the Chief Deputy City Attorney for the Consumer Protection Unit, and I have a number of our staff here today who will be presenting and talking about fair housing issues. We're here today because April is Fair Housing Month. This is the month that the Fair Housing Act was passed, and we celebrate it every year in April by having a symposium and talking about current topics related to fair housing, the importance of fair housing laws and our civil rights laws in providing opportunity and access to housing for all. And so we've tried today to create sort of a topical and timely presentation with some background and timely information about some local fair housing issues and context for fair housing issues here in Santa Monica, and also some tangible training and information on specific fair housing topics for specific groups that are, particularly vulnerable at this time. So we're getting a little bit of a late start here, so we'll just go ahead and get started. Just a brief overview of the agenda. As I mentioned, we're going to have a brief discussion of the history of fair housing barriers for Black and Latino residents here in Santa Monica, and a discussion of some reparative efforts that have been going on in Santa Monica recently and currently. So Denise McGranahan in our office is going to make that presentation, and Lisa Parson, who's with our city manager's office and the equity inclusion manager for the city of Santa Monica, will be presenting on that. And then we're going to have our sort of training portion and background portion of the event. Daliah Setareh from the Legal Aid Foundation of Los Angeles is going to do a Know Your Rights training about immigrants with a little bit of a focus on housing, but also just basic Know Your Rights information for immigrants as they're navigating the world and dealing with law enforcement and those sorts of issues. And then Jonathan Irwin Frank is going to talk about some specific legal protections for tenants in housing, so specific as they relate to their housing situation. And then similarly, we're going to do a discussion about fair housing and domestic violence survivors. Andrew Braver from our office is going to do a little bit of a background on Fair Housing Act protections for domestic violence survivors and why fair housing is sort of a gender justice and fair housing issue. And then Minty Siu-Kootinkoff from Sojourn and the People Concern is going to do a discussion about housing rights for domestic violence survivors. Again, sort of a concrete training about the rights that housing survivors have in dealing with their housing situations. So we'll go ahead and get started. Lisa will get us started. And we're planning to have some time for questions at the end. We do have a lot of content to get through, but we'd like to hold questions to the very end. Thanks.
Good morning, everybody. How you doing? Good. Nice to see everyone. I'm here to bring everybody down, and then everybody else can bring you right back up. No, I'm here to talk about some of the bad parts of our history here in Santa Monica. We have some good parts, obviously, but first we're going to just talk about some of the challenges. So starting with the Latino community, I'm going to go through these pretty quickly and just really do the highlights. But, obviously Santa Monica, Mexican land grants created the ranchos that started the land here in general, right? Beyond, obviously starting with the Tongva, but after that, the Latino community really planted roots here. The Pico neighborhood, which was originally called La Veinte, became a center of Latino life. That Pico neighborhood has been called that since the 1910s. The picture there is Pio Pico. That was an early politician, and that is who that neighborhood was named after. He really brought that community together. Homes, businesses, churches were built up in that time. In the 1940s to the 1960s, the World War II labor programs expanded the Latino workforce, drew more Latinos into Santa Monica. The construction of the freeway, which I'll talk about in a bit, was the biggest displacement of Latinos in Santa Monica. So I've done a lot of research on this as the equity inclusion manager for the city, and David, my colleague in the back, and I have been working on the city's equity plan for a couple of years now. And some of the statistics that we've learned in researching that are really interesting. There were more than, I think the city was about 45% Latino prior to the freeway. And after the freeway, as you'll see, those percentages are significantly lower. The siting of that freeway was just specifically cited to go right through a Black and brown neighborhood. And so right through, right, means destroy all those houses, but also destroy all the community connections that were there. So not only the people who lived where the freeway were left, the people who were no longer connected to their family members or connected to their church or connected to the things that were there also left. We did see a lot of activism and growth in the 60s and the 70s, trying to rebuild the community. The population doubled, nowhere near what it was before, but more that activism and community identity. That community identity is still really strong in the Pico neighborhood. You can feel it around Virginia Avenue Park and places like that. And then with Silicon Beach coming in the 2000s, we again saw the neighborhood starting to fracture. Just with the gentrification that happened, the housing prices shot up, the rental prices shot up. So it's essentially the Latino community is concentrated in rent control properties, and everything else is really held by wealthy people who have come in the later years. So there's a lot of really long tenured families in Latino families in Santa Monica who have left, who we have tried to get back in various ways, which we can also talk about in a bit. For African Americans, similar challenges, slightly different. Very early settlement in Santa Monica in the late 1800s, so even earlier than the Latino community. Phillips Chapel, which I have a picture of here, is still there. They just celebrated a really big anniversary. I think it was 125 years. And they're still there. They still do church service. They have all their old records. We're actually going to be going through their records to try to trace some of the people who were here in the past, because it's really hard to find out even who was displaced, right? How do you find out who was displaced by something? The city doesn't keep old utility bills, and the utility bills probably weren't paid by the tenants. They were paid by the white building owners or what have you. So have to be creative and think about who holds the records. And this church is certainly a place with a wealth of records, which is wonderful. But this church also was the home for a lot of community key people in the community, business owners, people who started the inkwell, which the inkwell, if people aren't familiar, is a double-edged term, right? There's a movie made about it, which is how I first found out about it. And it was one area of the beach where the Black people were allowed to go. When I saw the movie, it was the one area of the beach where the Black people wanted to go, right? It looked so fun, and like all the Black people went there and they had a great time. Then you learn, no, it was the only place they were allowed to go, right? There were no bathrooms, there was no facilities of any kind. And what you would hear from Black people was we could go to the beach for about an hour or two and then we had to leave because we couldn't eat, we couldn't go to the bathroom, we couldn't do anything. And so there was a lot of movement around trying to make that situation better. People tried to build beach clubs and things like that, but there was a lot of community pushback whenever somebody would try to expand the Black presence on the beach. We had restrictive covenants on the land for both Black, Latino, and Asian people, which really concentrated everyone in the Pico neighborhood. That's another thing that working for the city, I've worked for the city for 10 years now. When I first started working here, people were always talking about the Pico neighborhood. We've got to build up the Pico neighborhood. We need to invest in the Pico neighborhood. And I was always like, what's going on in the Pico neighborhood? Like, why is it so different from all the other ones? And I'll show you a map in a minute that'll tell you why it's so different from all the other ones. But continuing through this history, when the Douglas aircraft, you can see the museum that's still over there in Ocean Park. When that aircraft facility opened, a lot of Black people, again, migrated into Santa Monica. Again, the population was so much higher than it is now. People really came in during World War II to take those jobs. And it was a growing center of Black life, the Pico neighborhood. And then once again, the freeway and everybody coming back from that war, dispersion again. And then we also had just a lot of civil rights setbacks, and again, the freeway construction. The other thing that we had was really the big waves of eminent domain in that time. Sorry for my stuffy nose. And so there were areas of the community that were cited, kind of claimed as blighted. And I can say this because we have a museum to one of the neighborhoods, so I'm not saying anything that's up for debate. There was a neighborhood called Belmar Triangle, was largely a Black community. There were other races there as well. And if you ask the people who live there, this was their home. If you ask the people who had other designs for it, it was blighted. And so those buildings were actually set on fire. Those people were displaced as well. They largely did not ever come back. right? And so that's one of the problems with these big movements that happen. It's really hard to get those people back. We're trying. We're going to continue to try to repair those harms, but it's hard. And so drawing those people back into the community, restoring the levels of diversity that we had, it's crazy to be like, I'd love to get back to the diversity of the 50s. That's strange to say, right? But we were a little bit more diverse in the 50s than we are now. We are more of a wealthy white enclave in many ways. So some of the ways that racial injustice was codified in housing policies. So here you can see they're burning one of the buildings in Belmar. And here you can see the freeways on the bottom. So that freeway, there's a church there's a bus tour that we do sometimes for Black History. And on that tour, there's a church. And the church used to have a yard, a preschool, and a huge parking lot. And the freeway is now the back of the church. So when I say like it really cut directly through these centers of civic life, it directly went through. They couldn't bring themselves to tear down a church, right? But they tore down everything next to it and all that neighborhood. But, it was very explicit in the 1920s. So these areas would just say Caucasians only, right? They would say like it has to be Caucasians only, otherwise it's not safe. Right, which you can kind of still hear echoes of that sometimes today, even when the train started coming to Santa Monica, right? Everybody call it the crime train because people from other neighborhoods are going to come here, right? That people were saying that like 10 years ago. We still had, R1 zoning, which continues on to this day. And there was a lot of population growth from white people because it was like, oh, they're all restricted to this one area. Okay, well, then the rest of the area is safe. Great. Also in 1922, homeowners formed the Santa Monica Bay Protective League with an agenda of eliminating all objectionable features or anything now that it now is or will prove a menace to the Bay District or prove detrimental to our property values. Santa Monica Bay Protective League was a small cover for the KKK. And so they had a great name. That sounds nice, right? We're here to protect the community. But actually, they were here to protect the white community, and they were here to really aggressively find ways to push out communities of color. So we share this, and I did say I was going to bring everybody down. We share this not just to bring everybody down, but to say, right, like all of these things have ripple effects. It doesn't just happen and then we fix it, The freeway's still there. All those people are still gone. That Belmar neighborhood is still gone. And things continued after that, right? So in the 1930s, we had Caucasian-only deed restrictions. We started using redlining maps, which I'll show you in a second. In the 50s, we continue to have deed restrictions, zoning prohibitions, racist realtor practices. So Black people could only purchase homes in discrete areas of downtown, Belmar Triangle, which we then lit on fire, and a small area of Ocean Park. And this applied for Black people, Latino people, and Asian people. It wasn't just Black people also. And Jewish people, thank you. And Jewish people were also displaced by the freeway. There was a Jewish neighborhood that was over by the freeway, and it was also completely eradicated. It's gone. And we learned that. We got some great historical documents from a member of the community who was like, by the way, did you know? We didn't even know. And that's what happens, right? When people get erased, it's hard to even know. Then the freeway displaced 550 African American and Latino families as well as Jewish families. Their businesses are gone, right? So not only their homes, but their livelihoods are gone, loss of family wealth, all of those things. So redlining. These maps are really how we got it done in those days, right? So this is how the government qualified land. The best areas to live were green, still desirable blue, definitely declining yellow, hazardous red. Where's Pico? What color is it? Right. That's the only place where people of color could live, right? And that's why it was hazardous. So whenever everybody's like, what's going on with Pico? Like it was zoned to be that way. Right. And so it continued to be that way for a really long time. The people of that community actually built it up. It's a wonderful place. But it never really had the same resources or treatment or perception that the rest of the city had. So, right, the proliferation of these racial covenants in the first decades of the 20th century excluded persons of color from many residential neighborhoods in the city. After this went on, once we got rid of this, we still perpetuated this just in new ways, right? Like, so one of the ways you can perpetuate this is by requiring credit checks, but only of people of color, right? So then, oh, they just didn't qualify, or requiring oversized deposits for people of color only, right? So you're still preserving the composition of your neighborhood the way you want it, but you're not doing, it's not because of redlining, it's because they don't qualify. So these things just have a way of continuing to happen, right? Because now anything that changes those other areas is change that's maybe gonna, right? It's the crime train all over again. Sorry, the crime train really makes me laugh because I moved here from New York and like trains are great. Who cares? So the legacy of all this racial discrimination, right, is the population of African Americans through the 30s was lower than the national average. Today, still, the population is only 4%. We largely have single family zoning here, so that prohibits true integration. The highest resource neighborhoods are disproportionately white. And African Americans with generations of history, African American families, Latino families, Jewish families, Chinese families, Japanese families. I'm sorry, I left everybody off the slide. With generations of history in the city were forced to leave and cannot afford to return. So again, just another map of all the redlined areas. It's all the areas that people talk about now that need help, that we need to worry about. We need more police presence. We need this. It's the same areas, right? They were set up to be that way, and they're just still that way. They're much better than they even should be based on what was planned for them. But that's why these programs are so important, right? Is because they were set up to fail. They're still thriving despite. But there's reasons why we need, restorative programs and fair housing. So you can see the population by race here in the city. The white population has increased. Hispanic population has increased. The Asian population has increased. The sad thing that has really decreased, that is a side note of my own, is the Japanese population is very strikingly low here. And I just like to share that is because we, meaning city government, actively participated in moving Japanese people to the concentration camps during that war. And when they came back, because, city staff really identified them from the rolls and helped people pick them up and take them out, they didn't move back here, which I only learned because they moved to my neighborhood, which is West Adams, which is way over. And it's all of the landscaping is Japanese because they all moved there. They didn't want to come back here. So when I say like all these displacement and things have perpetual impacts, a lot of times it's really hard to get people to come back to the place where they were harmed. But we want diversity in Santa Monica. We want to have people feel like they have a fair share of living here, that there is a chance for diversity here, that diverse communities can thrive here. And we do see it in Pico and other areas, but it's something that we really have to focus on and foster because of these things from the past. So I think I get to turn it over to Denise now. Oh, is this still me? I think this is still me. Sorry, I lied. So a couple of things that we've started to do. Some things have been successful, some things are still in progress. One of the things that we tried to do, and this is what I was saying, is pretty hard to get people to come back. In 2021, we developed a right to return program. This was modeled after a bunch of other right to return programs. Portland was the first to really do a big swing at it, and they did a home ownership right to return program. They gave free down payments to city-owned homes. That was the difference. We don't have any of those. But they had city-owned property that they were giving to people, and they just had to get seated in the homes and be able to make a manageable mortgage payment. To demonstrate that you deserve to come back, you had to prove that you were displaced by a government action. It's very hard to prove it, right? Who has a utility bill or a postcard or anything from 1942? Right? It's really hard. So when I say like we're still trying to go through church records and things like that, it's because it's really hard to find documentation. So the same thing happened with our program. We know hundreds of people were displaced. We were able to find, after like a year of outreach, ads on KCRW, got picked up nationwide in the newspapers, 100 people applied. Of those people, I think 14 people got on this list through the qualifications. So we don't consider that a success, right? That's not what we were hoping. But it was a first step towards saying, like, how can we start to repair? The next, we did issue a formal statement of apology to African American residents and their descendants, which is engraved and in front of City Hall, which is really funny because I don't usually care for plaques. And then we had a different election, and then I was like, this is a radical statement, you guys. Like, it feels very different now, and I'm glad that it's there. But we are also in the office of diversity, equity, and inclusion, and across the city, everyone is working really hard to embed equity in what we're doing, advance progress, like try to be more inclusive, be thoughtful, make sure we don't replicate the mistakes of the past, because sometimes it was just people not realizing that they were being discriminatory, right? Even those people who were like asking for credit checks, they just weren't exposed to Black people or Latino people. They'd only heard that there has, like, if you see a map and it says everybody that lives in this area is hazardous, then you're like, oh, maybe I should check, right? So we need to make sure people are educated better. We need to make sure we're not doing things like that now. So we're doing a lot of work to do that, and it is progressing well, so that is great. And we are developing an citywide equity plan. We are also working on developing a reparations program for the city, which is a huge step forward for us and something that we've been hoping and not thinking was ever going to happen for probably 10 years. But we did launch a program on February 11th. We're going to do it right, so it's not going to be fast, which is painful for everyone involved because we'd love to start it tomorrow. But we do have an amazing task force of people with subject matter experts from all over who've worked in reparations before. It's led by my colleague, David Gardenier. Stand up, David Gardenier. Hooray! David Gardenier got engaged this weekend. And David Gardenier, so you all know, before he worked for the city, he formed his own nonprofit called Fund for Reparations Now. So imagine my delight to get him and 7 years later be able to pull it off. Now it was 7+ years, but we're doing it. But yeah, we have subject matter experts. We have people from the community that have deep historical knowledge of all of these ties, all of these breaks, who can fill in the gaps that we don't know. And our goal is to, and this is like, I've said this to council, I hope it was compelling. And I said, like, I don't want to do justice by lawsuit, right? Like, so often the only way any of these people get justice is they come and they sue the city and they say, like, you took my land or you took my, and like, I would love to do justice by policy and just be able to say, like, we know we did the wrong thing and we are going to make it right. And this task force is a really big step towards us being able to do that. So stay with us. We're working hard. They're meeting way too much. They're meeting like several times a day, I think. Well, between the different subcommittees, I think they are. They're working very, very, very hard. But I think we are going to produce something that the city can be really, really proud of, and that we can finally not make people come to us to say, you hurt me, which I think is really important, right? And I think that's some of what all of this fair housing is about saying, like, we know there's problems and we're doing something about it, right? We shouldn't have to have everybody come beg us all the time or sue us all the time or lodge complaints. We should be proactive and try to improve things. So that's what today is about, and that's what our work is about. And thank you. And I'm going to take one question because I have to leave after this. So if that's okay, I'll just take the one. Oh, sure. We can post them somewhere. Sure. No problem. I have plenty. I got lots more if you want information. Don't worry. Thank you.
I'm going to stand over here so people can see me because I'm so short. I'm Denise McGranahan, Deputy City Attorney, and I want to sort of shift over a little bit to talk about the city's obligations under the housing element. I think we have both the obligation to affirmatively further fair housing, which is kind of now not so much true on the federal level, but on the state level we still have it, and this kind of coincides with our housing crisis. We know we have a problem with having enough housing for people. So because we're in the midst of a housing crisis, the state has taken a lot of control over cities in terms of being able to determine land use. And I think a lot of citizens don't know this fact, that there are a lot of state laws that govern what can be built and where it can be built, and force cities to affirmatively further fair housing, which we think is a good thing because we want to have communities that are integrated. So losing control over local production is hard. And so I wanted to talk a little bit about that. So the state legislature has passed extensive legislation to encourage housing production at all income levels. And this will, and they've increased enforcement and penalties for noncompliance with housing element laws. And some of you who've watched city council meetings have seen this, this story play out over the last number of years. And there was a time when the city's housing element was decertified and then recertified. The city made a really good comeback there. But this is all coming from the state. So people need to understand that. And what I also want to talk about, because it's Fair Housing Month and because we feel strongly in California about the duty to affirmatively further fair housing, which is to essentially repair what has happened in the past in terms of segregation, and to integrate neighborhoods, and to, when we build housing, to thoughtfully think about where we put housing so that people can live in communities that are integrated. And this is all applicable to charter cities like Santa Monica. So beginning in 2019, Government Code Section 8899.50 was implemented, and it requires all cities in California to affirmatively further fair housing. This is a new obligation in the state. It's not true in other states because the affirmatively furthering fair housing obligation on the federal level has pretty much been dissipated. But now we still have this obligation. Everybody needs to know that in California we still have it, and it's very strong. We have to combat discrimination. We have to engage in meaningful actions to replace patterns of segregation with true integration and balanced living patterns, and foster inclusive communities, address disparities, transform racially and ethnically concentrated areas of poverty like the Pico neighborhood, for example. Even though it isn't really considered a recap, we need to work on that. And we need to comply with civil rights and fair housing laws. So this extends to all of the work that we do in the city, all programs, and we work very hard in the city attorney's office to make sure that our programs are also affirmatively furthering fair housing. One of the things that we have to do, it's not a federal, I don't think it's going to be a federal obligation for a while, but the state obligation is to do an assessment of fair housing, and we did one in 2021 where we summarized the fair housing issues in the city. We assessed fair housing enforcement and outreach. We analyzed federal, state, and local data and knowledge and trends and patterns regarding integration and segregation and disparities. And our assessment of fair housing showed this, that there's a profound pattern of segregation in renter versus ownership households, that the location of renters and owners in Santa Monica very, very highly correlates with patterns of residential, racial, and ethnic segregation. That areas with highest concentrations of home ownership, such as the north of Montana, Ocean Park, Sunset Park, there are also areas that are predominantly white. And those areas track the maps that Lisa showed you earlier. Interestingly, I actually wasn't aware of this before I did some research on it, that you're looking at the redlined areas and you actually see that those are the same areas that are now essentially still redlined. The areas with the highest concentration of renters, like in Pico neighborhood in downtown, also have the highest concentration of minorities. So our AFH has also found that a major contributor to continued racial and ethnic segregation is the economics of high housing costs and land costs, which is really an issue in the city. There are also displacements of residents due to economic pressures. We know that housing costs have increased due to Costa-Hawkins, which ended vacancy decontrol back in the 90s. Many of you are too young to know that, to remember that, but I remember when that happened, and everything changed. Tenant harassment became an issue. It wasn't an issue before that. It became an issue, and everything got more expensive and more Ellising. So we work really hard in the city to work on helping voucher holders be able to access housing in the city, and we have source of income discrimination law. We have a housing status discrimination law that prohibits discrimination based on whether you have a history of renting or landlord references, and you shouldn't be discriminated based on that. So we're working in the city to get landlord managers to comply with our laws in that regard. So we also, our AFH also talked a lot about how we have a really good record in the city. We've had an inclusionary housing program for 30 years. We've exceeded our regional housing needs assessment for low-income units. We have many LIHTC units earmarked for low-income families. But there are some issues, like it's difficult to access housing in Santa Monica if you don't already live here. We know this. But we also have recently implemented this small area fair market rents, which I think is really good because that makes it possible for people to access units in neighborhoods that they previously could not with their vouchers, and in a range of sizes of units. So I don't know if I want to go too much more into this. I think that we want to move on to the next presentation because we have time constraints. So I'm going to turn it over to Daliah. And I appreciate everybody listening to our conversation about this.
Good morning, everybody. My name is Daliah Setareh. I'm an attorney with the Legal Aid Foundation of Los Angeles. And so LAFLA, we are a multilingual nonprofit law firm, and we provide free legal services to low-income persons in the greater Los Angeles area. And we have an office right here in Santa Monica, now on Wilshire and 3rd. So come visit us. All our services are for free. And I'm specifically in the immigration unit, and that also, we don't just do general immigration, it's really geared towards vulnerable immigrant communities. So we work with victims of domestic violence, victims of serious crime, victim of human trafficking, persons who've escaped persecution abroad, and we work with children. Here are some of the other services that we provide. We have a big housing and eviction defense unit. Some of the attorneys and paralegals are here today. So today I'm gonna talk a little bit about Know Your Rights and some current updates. Immigration is like a hot topic now. One very important thing is that no matter what our immigration status is, we all have constitutional rights that nobody has the power to take away. And one of the key messages today, I think, is we're going to talk about, I think, over and over again, is the right to remain silent. That is a very big right that we all have, and that can really, if we pass that on to those who might be affected by immigration laws, that is something to pass on to let people know you have the right to remain silent, and we're going to talk about that some more. So obviously people come to the United States for many different reasons. Some because they're escaping civil wars. They want to reunify with family, escape all kinds of violence. and economic hardships. And also, immigration law is very unique. Each case is very unique. So oftentimes we hear like, oh, but my neighbor's petition got, approved in just, 3 months. How come mine isn't approved yet? Every case is so different. It matters how the person entered the United States. They come with a visa or without a visa. How long have they been here? So there's all these like very specific factors that go into determining, if somebody has relief for immigration or how long it would take. Here are just an overview of the immigration agencies. At the very top, we have the Department of Homeland Security, and underneath that are 3 branches. We have CBP, Customs and Border Protection, Citizenship and Immigration Services, and ICE. A little bit more into detail. So as Customs and Border Patrol, as the name says, they're a federal law enforcement agency located at the ports of entry. So LAX, for example, or Tijuana at the border. And they're responsible for customs, immigration, border security. And what they can do is they have the right to refer cases to ICE removal. So for example, if somebody is at LAX and they think that maybe their visa is fraudulent or they don't have a proper visa, or they notice, oh, you had been ordered deported and now you're trying to come back without waiting the proper time frame abroad, they could refer that person to ICE for removal. Yes. Next, we have USCIS, and that's the agency that processes applications. So for example, if a US citizen gets married to somebody undocumented, they would file a family petition that would be adjudicated by USCIS. They also can refer cases to ICE. So this now becomes political, even though these are immigration laws that have to be passed by Congress. The political element in it is the enforcement of it. So for example, in the past, we have gotten assurances that, for example, in a domestic violence immigration type of petition, let's say if the victim of domestic violence can't prove one of the elements. Let's say her family is refusing to send the marriage certificate from Morocco. We had a case like this. The family was like, no, you stay with your husband even though he's beating you. And so they would refuse to send her evidence of a marriage. So USCIS had given us assurances that even if they deny a case, that they would not refer it to ICE. Now, we're not quite sure what's happening. We think that now there is a likelihood that cases that are not approved and not for fraud reasons, but for other reasons, could be referred to ICE for removal. Lastly, we have ICE. It's a law enforcement agency that conducts criminal investigations and enforces the immigration laws. And they, for example, can put holds at the prisons, so they can go through the inmates list at the prisons and determine who may not have immigration status and may put a hold on them so that when the inmate finishes their term, they could go pick them up. And they can also issue notices to appear for somebody to have to appear in immigration court to fight their case. Here's just like a quick overview of some news. Some new laws or executive orders and some very old ones that are being renewed. The first one is an executive order severely limiting the ability for persons to request political asylum at the borders. And with that, also a complete suspension of the refugee resettlement program. We saw during the Biden administration, because I'm not allowed to say political things, during the last administration, we saw the effects of that. We had 80,000 Afghan refugees that were airlifted by our government to come to the United States. And so they were brought here, but there was no refugee resettlement program in place because it had been dismantled. And so the community had to step in to help resettle the refugees. Next, we have an order for increased detention and expedited removal. We're going to get more into detail. There's new designation of terrorist organizations. So of course, each country, always they have a standing list of terrorist organization. Recently, more organizations were added to that, specifically 6 Mexican cartels, and you could look them up, the specific names of them. Tren de Aragua from Venezuela, MS-13 from El Salvador, Iran's Revolutionary Guard Corps, Hezbollah, various different ISIS offsprings, and also the Russian imperial movement, which I hadn't heard of. It's a white supremacist movement. And also, this is the newest thing, is there is the Alien Registration Act of 1940 now has been revived. And this is the first time since World War II. And basically what this law requires is that anybody who is not a citizen in the United States has to register. There's a brand new form. This just went into effect in April 11th. And it's saying that anybody over the age of 14 who has been in the United States for 30 days or more, prior to those 30 days, they have to register and let the government know that they're here. It's a very scary thing because the government has said that this is being used as an enforcement tool. So we're getting a lot of questions, like, oh, should we register, should we not? And we really look at each case on a case-by-case basis and then let the immigrant make their own decision whether they want to take the risk to violate the law and not register, or register and then also be at risk. So it's a very difficult situation. We talked briefly about expedited removal. What is that? So interestingly, it was created in 1996 by Bill Clinton, and it says that the government can deport or remove somebody from the United States without having a hearing before an immigration judge. And we'll go over who is most at risk for that. I do find that very interesting that, this is not like a new law that is come into effect, but now this administration has said that even though this has been happening, expedited removal has been happening, but now we're getting a little bit, hearing more about it. So who's most at risk of expedited removal? Number one, people who've been arrested or are convicted of crimes. So as I said, somebody who's convicted of a crime, and especially of a violent crime or a crime where they're incarcerated, then of course, ICE has an opportunity to apprehend them once they're released. Number two, people who have been previously ordered removed by an immigration judge, but never left. So it could be that a judge orders, okay, I deny your asylum case or whatever case, you're ordered removed, you have 30 days to leave the country, and it could be that the person just simply didn't go. Those people are at risk. Or persons who were ordered deported or removed by an immigration judge or by Border Patrol. Let's say somebody was at the border, they were removed not by an immigration judge, but by CBP, and then they just re-entered unlawfully. Those persons also are at risk, especially since, again, IRA with Bill Clinton, there's much more stringent laws about fingerprinting and how their entries and exits of people are documented. Which part? So there's more stringent like fingerprinting, that there's now like a database, right? So when somebody gets apprehended by immigration, that they're fingerprinted when they're, that has been going on, yeah, since 1996. No, it didn't stop. It has been happening since 1996. Yeah. Now, but this is the newer part of expedited removal now, is that undocumented persons anywhere in the United States who have been here for less than 2 years are at risk of expedited removal. So for undocumented persons who've been here for less than 2 years, they can be removed without a hearing before a judge. If that happens to somebody, one way that they can assert their right, number one, is they could remain silent and not just like if they're stopped. We're going to go over more if ICE, with interactions with ICE. But one important thing that they can do is say, I am afraid to go to my home country. If that's true, obviously, right? If they're from Sweden, maybe they don't have such a good claim. But if they're from a country where they're actually afraid of going back home, they need to loudly say, I am afraid to go to my home country. Because at that point, a law kicks in where they need to be given a credible fear interview with an asylum officer. And if the asylum officer believes that this person has a credible fear of returning to their home because of one of the 5 reasons, such as their race, their nationality, their religion, their political opinion, or their membership in a particular social group, if they pass this credible fear interview, then they get a hearing before a judge. So they get taken out of this expedited removal danger. But if an undocumented person has been here for over 2 years, they should carry with them evidence that they've been here for over 2 years. And that could be, bills, medical records, school records, things that are not incriminating, like that show, that they may be from a foreign country, but any other kind of evidence that shows that they've been living here for over 2 years. Are you going to be covering sanctuary law? No, okay. So a lot of people ask, well, we live in California and we have a sanctuary law. Does that prevent ICE from attempting to arrest or detain a person? No. ICE is a federal agency and they can enforce federal laws irrespective of what state they're in. In California, we also have the California Values Act, which bars state and local police from investigating, interrogating, or arresting people based on immigration enforcement purposes. And this actually is very, very important since, I told you I work with vulnerable immigrant communities, so a lot of them are victims of crimes. And so law enforcement says that we need victims of crime to feel that they can trust local law enforcement so that they cooperate in the investigation or the prosecution of a crime against them. If there's an immigrant who thinks that, oh my God, I was just battered by my spouse, but if I come forward, they're gonna ask me immigration questions and then I might get deported. So from a criminal law standpoint, this is a great way to ensure that victims of crimes feel comfortable coming forward and collaborating with law enforcement. But as I mentioned before, it doesn't completely prohibit police cooperation, and that's specifically in relation to transferring certain felons to federal custody. Also, if there are warrants, the police cannot enforce immigration warrants, but they also can't interfere with that either. Again, just Los Angeles specifically, we have LAPD Special Order 40, which again strengthens that idea that local law enforcement is not going to be conducting federal immigration law. They're not at a traffic stop or at any kind of booking. They're not supposed to look at, or they're not supposed to ask about a person's immigration status. I already covered the sheriff in terms of inmates and their requirement to collaborate with the federal government. This also, unfortunately, is newer in that areas that were previously protected areas are no longer protected areas. For example, hospitals now are no longer protected areas. This means that ICE has the ability to enter a hospital and they can conduct a raid, but only in the common area. So they're not allowed to go to a patient's room. They're not allowed to go into a doctor's room. Churches are no longer a protected area, which means that if ICE has a warrant, for example, they can go into a church and execute that warrant. How about courts? ICE can also arrest immigrants at courthouses if they have credible information that a specific person that they're looking for is present. Now, we have not seen anything like this happening, for example, at immigration courts. Sorry, not immigration courts. I actually also haven't seen it at immigration courts, but at family law courts, for example, but possibly criminal courts, where there might be somebody who the federal government believes is a risk to national security or public safety. What are some of the rights that you or immigrants have? Whoops. Okay, what's happening? Okay, number one, you have the right to remain silent. That probably is one of the most important rights. You know, we have a cafe down at our new office, and the barista had an accent, and I was with a colleague, and she's like, "Oh, where are you from?" And he's like, "Oh, I just got here from Russia." I was like, no, like, do not answer questions like that. Like, where are you from? You have the right to remain silent. Like, you don't know who this person is asking you this question, right? So the right to remain silent and not give away such a vital information. You have the right to speak to an attorney. So, you know, if ICE comes to apprehend somebody, they can call an attorney. If there's no warrant, then you have the right to refuse consent to be searched, yourself or your car or even your home. If you're not under arrest, you have the right to leave. And you have the right not to sign any documents. And these seem so evident to us who may have stable immigration status, but if somebody is an immigrant, they may not speak English properly, and there's somebody in a uniform saying, sign this, you could see how it is very tempting, like, to want to appease. So this is a message to send. No, you can remain silent. You do not have to sign documents without first talking to an attorney. What are some of the rights persons have at their home? If ICE officers are at the door, you or anyone has the right not to open the door unless law enforcement has a valid warrant. If they have a valid warrant, first of all, if they just have a warrant, before you open the door, you want to first make sure that it's a valid warrant. So you can ask for identification. Who are you? Are you the police? Are you ICE? Who are you at the door? Then ask them to slide the warrant under the door so you can examine the warrant to make sure that it's a valid warrant. If they don't have a warrant, then you just say, I don't want to answer questions, and don't open the door. If they do slip something under the door that looks like a warrant, you want to make sure that it's a valid warrant. Here are some ways you can check. Number one, the signature on the warrant has to be from a judge or from a judge, not from somebody from ICE. Okay, so it has to be a judge. There has to be a seal from the court that says judge on it or magistrate. And it has to have the correct address, even the correct apartment number, the correct name, the correct spelling. If any of these are missing, then it's not considered a valid warrant, and the person is not obliged to open the door. What if ICE is at the door without warrant. Then the person can simply say, I do not consent to you being at my home, please leave. If you do have valid immigration status, the person may want to think, like, is it better if I just show that I have valid immigration status to kind of like get them to move, to leave. But also what's important is that a lot of people live in mixed immigration homes, which means that some people may be citizens, some may not be citizens. So it's really important also if somebody's a citizen and they feel like, oh, well, I'm safe, but ICE can come and collaterally also arrest others in the home if they find out that, oh, they're undocumented, especially if they've been here under 2 years. So there's a lot of considerations. What are some of the obligations or rights of a landlord vis-a-vis ICE at a home? If law enforcement has an arrest warrant for a person and goes to that person's home, they have the right to enter the premises with or without the landlord's consent, and even with or without the tenant's consent. However, law enforcement still cannot bypass the tenant's rights, so they can't just go to the landlord and show the warrant and say, open the door. They can't do that. They still have to knock on the door and go through the procedure that I just described, right? Identify themselves, show them the warrant, and then the tenant can open the door if there's a valid warrant. But if the tenant is not home, law enforcement can actually ask the landlord for access to the home and enter the home. Now, law enforcement can ask the landlord. Whether the landlord cooperates or not, no, that's up to them. He's going to cover that. Okay. Sure. Sure. Okay. Do you want me to stop? Okay. I have so much more to talk about, but we'll do it another time. Thank you.
Okay, so now that Daliah has so helpfully laid out the general landscape for immigrants today, we're going to kind of narrow down and focus on protections that we have for immigrant tenants in California, and these are state law protections and also some city of Santa Monica local protections as well. Thankfully, going back to after the 2016 election and even before that, the state government and city council were focused on making sure that tenants were protected regardless of the immigration enforcement situation. And so there are a number of good laws in place. And so these are the categories that we're going to be talking about. All right, starting with prohibitions against immigration-related threats, harassment, intimidation, or coercion. Okay. So first thing to note is that these protections apply to tenants, occupants, and prospective occupants and tenants. So kind of regardless of the particular status, which I think landlords here will be familiar with, whether it's an occupant or a prospective occupant, they don't need to legally be a tenant in order to be covered by these protections. So it is unlawful to threaten to report immigration status to try to get a tenant to move out. This is a part of the city's tenant harassment ordinance as well as state law. To disclose immigration or citizenship status to any person or entity, again with that intent requirement to get a tenant to move out or to harass or intimidate a tenant. And lastly, to disclose immigration or citizenship status to any immigration authority, law enforcement agency, or other government agency, again, with that intent to get a tenant to move out or harass or intimidate a tenant. So just because under federal law, there may be a right to arrest someone or remove someone. Doesn't mean that a landlord can use that against a tenant if their intent is to get them to move out or to harass them or intimidate them. To force a tenant to move out involuntarily because of their immigration status, or to bring an eviction action against a tenant because of their immigration status, unless enforcing affordable housing requirements. So there may be, for example, in the voucher program or other federally funded programs, requirements related to immigration status. In that case, it may be lawful to bring an eviction action to make sure that you're complying with those affordable housing program requirements. But other than that, a very limited exception to actually evict someone simply because of their status is not lawful. All right, and I'm not going to read these all out to you, but just again, there are multiple state statutes in California as well as the Santa Monica Tenant Harassment Ordinance. Okay, and just a quick note, the state law also provides that a landlord is not prohibited from complying with any obligation under federal law, including for affordable housing programs. So again, if it's something like the voucher program or another federally funded program, and you're required to review citizenship status or make sure that the tenant in a federally funded unit or with a voucher has a certain status, that is lawful under state law. Okay, anti-retaliation protections. Okay. And so this is the conduct that you can't do if the purpose is to retaliate against a tenant. And so you can't disclose to, again, any person or entity, not just immigration authorities, but any person or entity, information regarding the immigration or citizenship status of a tenant, or disclose to any immigration authority, any of those entities or government agencies, or state or local law enforcement agencies, or other government agency regarding the immigration or citizenship status of a tenant, or threaten to report a tenant to immigration authorities. Okay, and what tenant conduct is protected? In other words, if a tenant exercises their rights in any of these ways and they retaliate by doing any of those things on the previous slide, that would be unlawful. So complaints about apartment or common area conditions or about habitability, these are the standard things we see all the time. Mold, infestation, appliances not working, anything like that. Exercising any right under law, including federal, state, county, or local housing, health, or safety, fair housing, or other tenant protection laws. And the state law also specifically lists organizing or participating in a tenants association or a tenants union. You know, tenants may get together and all decide that they're not going to pay rent for a period of time and they're going to put that money in trust in order to exert pressure to have repairs done, for example. And so just a few examples down there: contesting a rent increase that the tenant believes is unlawful, refusing entry that's not lawful under California Civil Code 1954. So Daliah was just talking about not being able to, not having to let law enforcement into a unit without a valid warrant. It's worth just a quick refresher. Under Civil Code 1954, a landlord cannot enter a tenant's unit except for a specific and limited number of reasons, including necessary and agreed upon repairs. And lastly, filing a rent reduction petition with rent control. Again, this isn't meant to be an exhaustive list at all. These are just a few examples. It's very comprehensive. It's exercising any right that the tenant is that the tenant has under law. They can't be retaliated with actual reporting or threats to report to ICE, to any of those agencies Daliah was talking about, or to anyone else about their immigration or citizenship status. And again, I'm not going to read all of these out, but you can see that this is in the city's tenant harassment ordinance as well as several places in state law. Okay, prohibitions on immigration-related inquiries by landlords. Okay, a landlord cannot make an inquiry regarding or based on immigration or citizenship status of a tenant prospective tenant, or prospective occupant of a residential rental property. So whether or not that person is already living there or it's someone that's applying, and this includes questions on an application. And they cannot require any tenant, prospective tenant, occupant, or prospective occupant to make any statement, representation, or certification concerning their immigration or citizenship status. Again, so that should not be either directly or indirectly a question on an application. Okay. Again, a landlord is not prohibited from complying with an obligation, so not a suggestion, but a legal requirement under federal law, including, as I discussed earlier, obligations related to affordable housing programs where there may be a immigration status requirement. A landlord is not prohibited from requesting information or documentation necessary to determine or verify financial qualifications or to verify the identity of a prospective tenant or occupant. We're going to go into this in a little bit more detail here in terms of asking for a social security number. So of course, one of the ways in which this could come up is asking a question that may not necessarily be directly asking about immigration status, but asking for some sort of information or identification where if someone can provide that, they would be a citizen or a permanent resident. If they can't, you would know that they're not. And that's why, consistent with that, the first bullet there, a landlord shouldn't request a social security number without also providing the option of providing a tax identification number, which would be a way to get that financial verifying information, but allow another option that wouldn't necessarily indicate what someone's status is and could serve the same function in terms of financial verification. So again, any application question asking for a social security number should also ask for and provide the option of providing that tax identification number. And a landlord should not discriminate against or reject an applicant who provides that identification number rather than the social security number. Okay, so we wanted to go into credit screening a little bit. This is another area in which this question could come up. If a third-party credit screening requires a social security number, then any inability to use that third-party screener should not be lawful grounds to reject an applicant. And a tenant who declined to provide a social security number should be given an opportunity to provide their own credit report if that third party is not going to work because they require that number, or to provide alternative evidence that they'll be able to reliably pay their rent. Now, as a general matter, alternative evidence should be fairly considered in order to avoid arbitrarily or unfairly discriminating against tenants without traditional credit. It's widely known that tenants do prioritize their payment of rent. They may be receiving benefits that are incredibly reliable, and there may be other ways in which a tenant could show that they're very reliably going to pay their rent. Even in just thinking about it in terms of rational basis type review, we want to avoid arbitrarily discriminating against tenants who don't have that traditional credit, but who can show that they'll reliably be able to pay the rent. Okay, again, this is the state law that is the source for these protections. And I believe that this presentation, either on YouTube or maybe even the slides, will be available. So if you do want to get those citations, you should be able to do that. Okay, so discovery and litigation protections. California has also made sure that if tenants are involved in legal proceedings and litigation, there are protections related to immigration status. This is important, just like we were talking about with law enforcement. You also don't want tenants who have been harmed in a way that would be civil or would be pursued through a civil lawsuit to, not bring a lawsuit for tenant harassment or for discrimination or fair housing violations because they're afraid of some kind of immigration retaliation or something happening related to their immigration situation. So these first two, basically in a personal injury lawsuit, as well as legal actions in these different categories: employment, civil rights, consumer protection, housing laws. This would include things like tenant harassment and fair housing lawsuits, asking about immigration status. Well, in the first category for a standard personal injury, it's prohibited and status cannot be admitted to evidence. In the second category, it's prohibited unless a party can show by clear and convincing evidence that the inquiry is necessary to comply with federal immigration law. That's similar to that exception that I talked about earlier, only if it's an actual requirement in order to comply with federal law. State law also provides that immigration status is irrelevant to the issue of liability in these matters. And I just put in a note there that inquiries into irrelevant matters are prohibited even under the generally very broad discovery standard. So that means if you're in a deposition, for example, and you're defending someone, if someone is asked about their status either directly or indirectly, the lawyer on the other side or the person being deposed, if they know this, can say, that's not that's a prohibited question, it's irrelevant, it's not something you're allowed to ask about, even in written discovery or in a deposition. And again, we have several sources of law for that protection. Okay. Lastly, non-discrimination protection. So people may be familiar with the categories of non-discrimination that are in federal law. California law is actually broader in terms of the categories that are explicitly listed that are protected. Here we're talking about immigration status and citizenship and primary language. So those are explicitly listed as protected categories under California law. And so they would be treated similarly in terms of non-discrimination as categories that we may be more familiar with, like national origin, ancestry, race, color, gender, etc. Okay, so what kinds of discrimination are prohibited? Refusing to rent to someone or discriminating against them. So obviously just flatly refusing to rent to someone because of their status, that would be unlawful discrimination. But so would prioritizing other applicants. You have a number of applications that come in, you choose someone who applies later because you prefer them based on their immigration or citizenship status. That would be unlawful discrimination. Again, protections apply to undocumented tenants and applicants, as well as every other status. There's numerous categories under immigration law, but that would include temporary protection, any visa status, as well as permanent resident, citizen, etc. And they generally get, again, the same protections as other categories that are protected under non-discrimination law. And so the two main sources of law for this are the California Unruh Civil Rights Act. That's the one that lists out all of these categories, including the immigration status. The California Fair Employment and Housing Act. I point to that subdivision. That's the one that kind of loops in these other categories that are listed in the first statute. Okay, I think we're going to do all the questions together. So that is it.
Thank you very much. This next section is going to be about Fair Housing Act protections for domestic violence survivors. And then after I introduce this, there'll be a more fulsome discussion about state law and federal law protections for domestic violence survivors in terms of tenants' rights. So I just want to give a quick overview as an introduction to this topic. So what we have here in small print, I don't know if anyone can read it, but if anyone knows what that is the Fair Housing Act, which is what we are here to celebrate the anniversary of. That was passed in 1968, I believe. So there it is, the Fair Housing Act, and that's only part of it. It goes on. But just to review what it is, the Fair Housing Act is a federal law that prohibits discrimination in housing because of certain protected classes. These are race or color, religion, sex, national origin, familial status, and disability. In addition, California has its own fair housing laws, multiple of them, as we heard from the previous speaker, that include these categories and others as well. So in that tiny text there, you'll see that there's actually many different ways that the Fair Housing Act protects against discrimination because of these categories. For example, the denial of housing based on one of these categories or classes, or not giving certain benefits to those particular tenants, or advertising in a way that discriminates. All of those are covered in that tiny little text over there, and many other forms of discrimination as well. So when we're thinking about the Fair Housing Act and discrimination against victims of domestic violence in particular, we actually have some guidance from the Department of Housing and Urban Development. So the US Department of Housing and Urban Development in February of 2001 sent out a memo that they titled Assessing Claims of Housing Discrimination Against Victims of Domestic Violence under the Fair Housing Act and the Violence Against Women Act, which we'll hear about from the next speaker. So I want to go through just briefly this memo to sort of frame the conversation going forward that the next speaker will give, going into the specifics of state and federal tenants' rights for domestic violence survivors. So for background, survivors of domestic violence often face housing discrimination because of their history or because of the acts of their abusers. And statistics show that women are overwhelmingly the victims of domestic violence, although men too are victims of domestic violence, and all of these rights apply equally to both men and women. And finally, for background, domestic violence survivors who are denied housing, evicted, or deprived of assistance based on the violence in their homes may have a cause of action for sex discrimination under the Fair Housing Act. So that's what we're here to discuss. There are a couple legal theories that this memo introduces that could be used as a basis of liability under the Fair Housing Act for sex discrimination against victims of domestic violence. The memo lays out 3 different types of theories: direct evidence, unequal treatment, and disparate impact. And often in fair housing litigation, we talk about intentional discrimination or disparate impact discrimination, and these track those as well. So under the first theory here for direct evidence, the example given by the Department of Housing and Urban Development in this 2011 memo is when a landlord tells a female domestic violence victim that he does not accept women with a history of domestic violence as tenants because they always go back to the men who abuse them. His statement then is evidence, direct evidence of discrimination based on sex. So that's an example of direct evidence. They also provide an example of unequal treatment. For example, a policy of evicting households for criminal activity may be applied selectively against women who have been abused by their partners, but not against the male perpetrators of the domestic violence. This would be an example of a legal theory of unequal treatment. And then finally, this memo refers to disparate impact as a legal theory. Disparate impact cases often arise in the context of zero tolerance policies, under which the entire household is evicted for the criminal activity of just one household member. So, pardon me, let me go back. So that sort of frames the conversation, I hope, for the next presenter who's going to go into the details of both state and federal law protections for domestic violence survivors. Come on up. Seems to have skipped ahead here. So let me see if I can get it.
Well, I'm going to let you figure that out, and
I know it's confusing to go back.
while I'm chatting away.
Go ahead and I'll just do it manually.
Okay, cool. So hi, I'm Minty Siu-Kootinkoff, another recovering legal aid lawyer. And I'm the Legal Services Director at Sojourn, which is a project of the People Concern, which has been serving the community in Santa Monica for over 50 years. We provide services for homeless individuals, as well as through Sojourn, our project for domestic violence survivors. And we believe that everyone should be housed healthy and safe. So thank you for tolerating my little plug. So I'm going to go over some of state and federal remedies for domestic violence survivors and put some tools in your toolkit for people who are working with DV survivors. So first I'm going to go over the remedies that are available for people interacting with private landlords. Oops, down. Yeah. Okay, so if you are working with a survivor, they'll have certain rights when they want to leave and that one of the most important things is the right to early lease termination. Under Civil Code 1946.7, a tenant has a right to early lease termination. We've seen in many domestic violence situations where as soon as a DV victim moves in with the perpetrator, they sign a lease, and then the next thing you know, they've discovered that the person they've moved in with is not somebody they want to be living with for a year because they're dangerous to them. And the abuser has a lot of power over their victim because the victim is now trapped in a household with no ability to escape because no one can afford to pay rent in 2 places, right? So that's why CCP 1946.7 allows a tenant to terminate their lease obligation after 14 days. So instead of having to live a full year with a dangerous or violent individual, a victim of domestic violence can notify the landlord that they need to leave, and they can get out of the lease after 14 days. Now, who's eligible? Because I'm sure landlords are concerned that everyone would want to be eligible to terminate a lease in this way, but not everyone is eligible. It has to be a survivor of domestic violence, sexual assault, stalking, human trafficking, elder abuse, a crime that causes bodily injury, or a crime that uses force against the victim. So not everyone is eligible for early lease termination. They need to demonstrate their eligibility to the landlord. So what does the survivor need to submit to the landlord? They have to submit a written request to the landlord and documentation such as an emergency protective order, a restraining order, a police report, or a statement by a qualified third party. So somebody who is like a doctor, a nurse, a therapist, a domestic violence counselor. Those are people who can also help a survivor document that they're a victim of violence in order to exercise their rights for early lease termination. So if you have someone, they can, request early lease termination. They just need to be able to document it with some kind of evidence that is relatively recent in time, because the documentation has to be issued within 180 days of the request for the early lease termination. Okay, so if a survivor wants to leave, there are tools to let them leave. Oops, it's doing it again. And I'm going to take it personally because everybody else had no trouble with their PowerPoints. Okay, so, but sometimes the tenant doesn't want to leave, right? They want to stay. So what can they do to be safe if they've decided they need to stay in the apartment? Okay, I am going to take this personally. This machine doesn't like me. Okay, so what can a survivor do if their safety hinges on staying in the apartment? Well, one of the things they can do is request a residence exclusion order. That's one of the elements of a restraining order, because if one goes to court and requests the restraining order, there's lots of types of relief you can request in a restraining order, like a personal conduct order, a stay away order, child support orders, attorneys, fees, gun relinquishment. But among those many things you can ask for as part of a restraining order, you can ask for a residence exclusion order. And that is when the court orders somebody who's dwelling in a unit to leave the common dwelling so that the victim can stay in the apartment. Now, getting a residence exclusion order as part of a restraining order, and it can be done on no notice, does have a higher standard to demonstrate than other elements of a restraining order, because a restraining order can issue upon proof of abuse that can include nonviolent disturbance of the peace or coercive control. In order to qualify for a residence exclusion order, the survivor has to show there has been threat of violence or violence in order to qualify. And so there's a slightly higher standard to get that residence exclusion order, but it can be very vital because not everyone can get into a domestic violence shelter. And so sometimes people have to stay because in a county of 10 million residents, there are less than 600 domestic violence shelter beds. And so leaving is not always an option. For some people, staying is the only choice they have. And so a residence exclusion order is one tool in the toolkit for people who are domestic violence survivors who need to stay in the unit in order to be safe. Other tools in their toolkit is the right to a lock change at no cost to them. So if the abuser is not a tenant, then the tenant can ask the landlord to change their locks at no cost to the tenant and ask them to change that within 24 hours. And the tenant has to provide the same type of documentation that we talked about earlier with the early lease termination, a police report, a court order. Now you can include, request that lock change based on the statement of a qualified third party. And so the tenant, if they need to be safe, they can ask for a lock change. It's a little stricter when the person they need protection from is a co-tenant and that person is also named on the lease. They can't ask for that lock change unless they present a court order. Okay, so police report won't be sufficient to lock out a co-tenant, but with a restraining order, they can make that same request. Landlord, please change the locks because I need a lock change to be safe. Here's a copy of my court order excluding the other party. And then the landlords have protection and immunity. Oops. Okay, now, other protections for survivors of domestic violence. Landlord can't evict them based on an act of abuse against the tenant, right? So for those people who have done eviction defense, you're familiar with those eviction claims where the landlord says, you've caused a nuisance at the premises. There was an incident, the cops were called, your front door was torn down. This is too much chaos for our building. We'd like you to leave. Well, victim can defend that eviction and say, by explaining that that act of nuisance was an act of abuse against them and they didn't control that, and there's an eviction defense for that, okay? The landlord can still evict, though, if the abuser was a tenant and is a threat to other tenants and the DV survivor actively, voluntarily consented to the presence of the perpetrator. This is a change a little bit in the law. It used to just say that the tenant consented to the abuser being on the premises, but now it's active voluntary consent because in many cases, survivors of domestic violence can't really control whether or not their abuser returns to the property. Another new eviction protection is that the landlord can pursue a partial eviction of only one party in a DV situation. And now we talked about the rights that I just described are all available to people in private housing dealing with a private landlord. There are more rights to people in government subsidized housing, and let's go over that. Covered housing includes Hopwell Public Housing, Section 8, people in homelessness programs, housing for elderly, supportive housing for people with disabilities. I think in Santa Monica, we don't have all of these types of HUD housing, but we do certainly have some Section 8. We do have supportive housing for the elderly, so this is applicable here in Santa Monica, even though we don't have all these covered entities. Okay, so the HUD VAWA protections kind of parallel some of the private housing protections. There's no denial of assistance, there's no eviction, there's no termination of assistance to a DV survivor because abuse was committed against them, or for reasons related to abuse committed against them. They're entitled to emergency transfers. So if a DV survivor needs an emergency transfer, they can make that request and be eligible for that emergency transfer. And what is determined to be safe for them is something that the tenant will decide. Because even if the PHA thinks that they're going to be safe if they're in the next apartment over, the tenant might not feel that way. And so it's the tenant who makes that determination what a safe emergency transfer would be for them. And they can't lose their Section 8 benefits for trying to exercise this emergency transfer. Lease bifurcation. Again, similar to what we talked about with private landlords, a survivor might be in the same assistance unit as their abuser. If that is the situation, they can go to the Public Housing Authority and request the removal of the abuser from their assistance unit. And if it is the abuser who made the assistance unit eligible for the voucher, then the client, the tenant, the victim would have more time to kind of ask, to make themselves eligible. If it's like a public housing unit or something where you have to qualify, the victim can have additional time to make themselves eligible for the unit. Documentation. Oh, good. I'm going to finish in time so we can actually do Q&A. Woohoo! And then the documentation for any of these kinds of domestic violence protections are a little bit broader than it is in the sector where you're dealing with a private landlord, because when you're dealing with the private landlord, police reports will do, third-party certifications will do, but when you're dealing with the Public Housing Authority, the survivor can also do self-certification. And so they can sign a document attesting to their own victim status in order to qualify for some of these VAWA protections. Now, these tools for your domestic violence and housing toolkit are only some of the tools. So if you have people who might qualify or do need help with domestic violence protections, make sure they contact Lynn or me. And this is our 24-hour domestic violence hotline. We do provide domestic violence services and our phones are answered by a live person 24 hours a day. And now there's actually enough time to do Q&A.
We have a few minutes to take some questions. We can start a little line over here on the side. And we'll have another microphone for people to ask questions. And if folks come up here, turn on the lights a little bit.
So my question, I think, is for Daliah. Is that your pronunciation? Daliah. So my name is Matthew Millen. I'm a former legal aid attorney from LA, but that was a long time ago. So the initial housing element by the city was rejected by the Department of Housing because they found there was a pattern of segregation that perpetuated the segregation of the Pico neighborhood. So I'm curious why your office, the city is proposing to demolish Bergamot to build 700 of units of low-income housing in the Pico neighborhood, and Metro is proposing to build 375 units next to the cement plant at 17th and Colorado, also in the Pico neighborhood. So how does 1,000 units of low-income housing built in the Pico neighborhood not violate affirmatively furthering fair housing? Why are both of those projects going forward?
Well, I don't think that the obligation to affirmatively further fair housing can be looked at in isolation. Like, you can't just say this project, you can't build projects in the Pico neighborhood because that wouldn't affirmatively further fair housing. You have to look at the whole city, and there are projects being built in other areas of the city that are less impacted. For example, the HC project that recently was approved is, I think in Wilshire, I'm not exactly sure the neighborhood, but recently was approved a supportive housing project. So I think that you have to look at the entire map of the city and see what projects are being built. And a lot of it has to do with what landlords are proposing, where they want to build them.
These are both government agencies. This is the government, right? Metro wants to build I don't know anyone that wants to live next to a cement plant. Everyone I ask, do you want a cement plant built across the street from your house? They say no. But Metro wants to build 375 units next to a cement plant. Who wants to live next to a cement plant? Why aren't, and it's in the Pico neighborhood. I don't get it. I don't know why you're not suing to stop it.
I don't think I can specifically answer.
Lydia Ponce, fast becoming a housing liaison in between LASA's failure, the city and the county. I wanted to know, I didn't hear anything about the implications or the use of the Mellow Law as it pertains to the 2 miles within the ocean. If there's any fair, equitable housing laws, is it applicable within fair housing? Because they have a great EJ. The California Coastal Commission has a great EJ policy. And it would be complementary to the work that you're doing and a great complementary work that they're doing, because you're federal, it's federal law, and then you have state law. So instead of butting heads, because I know what happened with Mello in Los Angeles, for example, Mello, the city of Los Angeles took the power back for Mello units. And that really pulls away from the segregation issue, like for like. If you have market rate units in the building and you have below market rate units, you can actually say if they have granite marble countertops in the market rate apartments, then it's like for like. The low income apartments have the same. And the discriminatory policies, the EJ policies for the state of California is really beautiful. And I think you would complement each other and it would strengthen your resolve. I wanted to know, I had, the second thing was not just Mellow, but basically encouraging you. I guess it was, my statement was to encourage you to look at the EJ policy, the environmental justice or the justice policy for people, for the California Coastal Commission. For the DV, I find it very difficult to point to services that are available. Thank you, Sojourn, for being here. In your experience, is there an average time, if there is anything normal about these things, how long does it take for a DV voucher for a person with a voucher to be placed in a safe home or a safer home? Because we just have personal experience right now as being advocates for housing that people are taking 9 months to find a place, and they should be expedited, and I don't know how those are expedited. Thank you.
Well, fortunately, Santa Monica does have a program for that. I'm not saying that, there's definitely not enough housing. And from, those of us who are working with survivors trying to get people placed, there's definitely not enough housing, anywhere. And all of it is a struggle, and we work really hard to try to get our residents placed.
I actually don't have a specific answer to how long it takes. We could ask our housing department if there's any kind of
If I may, since there's no one else asking a question, what we're finding is that there's a pattern in practice in regards to people applying for affordable housing, and there is discrimination, as we know. There is it's interesting that you don't have abilities or age for people with children or people without children. The discrimination is all over that. The fact that there isn't an app drives me absolutely crazy, in the sense that someone applies or someone puts in a complaint. There should be an easy place on a website or even at the library printed to say, expect this, or this is what this is an FAQ in multiple languages, right? But I guess the problem is that because there's such a great need and financing right now, budget time, everything's going crazy, there is no fluid way in communicating. I am so happy to hear that you answer your phones. So what we need is to perhaps create a FAQ have connectivity flow to take people out of their trauma and to start them on the path of life. I'm heard, I'm seen, we're going to do this. It's so difficult when you have people applying for low-income apartments or in the case of necessity need and wanting to get out of a tent or rough sleeping. They're just all over the map. And we would like to point to something, say, these people are here for you. This is what this is made for. You know?
Yeah, in terms of the city website does have a lot of information and a lot of FAQs. It's kind of hard to know what, I think there were a lot of different categories of information that you're asking about there. Certainly, the housing division has a website where they talk about, the below market housing program and the voucher program. We have information about tenant harassment and about other programs, and also the form to be able to submit a complaint on our city attorney website as well. I wanted to briefly note, I think you mentioned some other categories. I didn't want there to be any confusion in terms of discrimination. Certainly the state and local law, things like family status, age, gender, other things that were mentioned, those are all categories that we do enforce at the city attorney's office and that are covered by state and local law. I don't know if someone else had anything else they wanted to add.
The idea of an app is great. We can certainly mention that to our housing department. I mean, a lot of that may be, the technology may also be costly, and but I think an app is kind of appropriate in today's world. So it's a good idea. So we can pass it on.
Thank you for your comments. Did we have anybody else? Any other questions?
With the DV victims, if there is a exclusion order, the remaining the abused person is there. Are we allowed to income qualify them, or do we have to have them income qualify? Perhaps they were roommates or they qualified together for the apartment. Is there that? Do we have to do that? Like re-qualify them to stay in the apartment?
The law doesn't specify from that perspective if it's a private landlord. And so it's something that the survivor will go to court and they may ask for payment for rent as part of their request to the court, and it'll be up to the court to decide what the court will order. But it doesn't tend to make orders directed to the landlord. It has to do with the victim and the abuser. And so it'll make orders perhaps saying that the abuser must leave the apartment. But as to making sure the rent is paid, then that's something that the victim has to make sure that the victim continues to pay.
Just to address that question, if one person is forced to be removed from the unit, like you have two people on a lease and one of the occupants is forced to be removed by the court, the landlord wouldn't necessarily be entitled to force that remaining tenant to requalify, particularly if they're subject to any of our local just cause eviction laws in Santa Monica, which apply to pretty much all multifamily housing. So you would not be able to require a tenant who's already living there in good standing to go through some new application or certification process. There would be no, if they chose not to do that or decided not to do that, there wouldn't really be a consequence for that, since that wouldn't be a just cause to evict the tenant. Not recertifying or not requalifying for your unit wouldn't be a just cause to terminate a tenancy if there's like a change in the composition. In addition, under our local laws, just cause eviction laws, if one occupant moves out, the tenant who remains can replace that person on a one-for-one basis as a subtenant, and so the landlord can't unlawfully or unreasonably withhold approval to do that, even if the tenant's lease says you're not allowed to sublease. If one occupant has moved out, the remaining tenant does have the right to bring in another subtenant. So you might see that happen where as they said, someone who's been forced to leave was contributing to the rent, the remaining tenant wants to stay in the unit, it's sort of on that tenant to continue to pay the rent, and they might choose to do that by bringing in another subtenant, and they would have the right to do that.
Well, on that note, with the subtenant involved and you have a subtenant, if the original leaseholder leaves, does that subtenant then have to leave too as well? Because it's under that
Yeah, I
original
mean,
contract.
I would need to speak with your, sort of the attorney at what their legal status is, whether they've acquired their own tenancy rights. It depends what sort of just cause eviction law you're subject to. Under our local law, there's a provision for if the only remaining person after all tenants have left is a subtenant who is not approved by a landlord, there might be a just cause to remove that tenant or subtenant. But it's going to depend sort of on the facts of the case.
Mhm. Well, with that subtenant, don't they have to qualify through the procedure as did the original?
If
Like,
if they are the remaining tenant subtenant, then they actually don't have a landlord-tenant relationship with the landlord. Their income and creditworthiness is sort of not relevant or material to any consideration the landlord might be able to apply to approving that person. They would be entering into a landlord-tenant relationship with the surviving tenant only. And the surviving tenant's sort of the one who's taking on the risk of bringing in another person who's going to owe them rent and be obligated to pay the rent. But the landlord generally doesn't have the right to require that a true subtenant submit to all of the same credit screening, or that they pass all the same credit and income screening that the landlord would apply to a tenant who the landlord is actually entering into a direct lease with.
thank you.
Thanks for that question. That was really helpful. Any other questions? All right. Anything else anyone up here wants to add? No? Thank you all very much for coming, and we'll see you soon. Thank you.